Action arises from an accident which occurred at the intersection of 103rd Avenue and 127th Street in Ozone Park, Queens, when a bus owned by the defendant Green Bus Lines and operated by one of its drivers collided with a car owned and operated by the defendant. The plaintiff, a passenger on the bus, was injured in the collision. Following the accident, the injured plaintiff and his wife commenced the action against the bus company, the bus driver, and City of New York. The plaintiff alleged that Brooklyn Union negligently placed construction equipment on the southeast corner of the subject intersection, which contributed to the accident by obstructing Raymond's view of the approaching bus. After discovery had been conducted, Brooklyn Union separately moved for summary judgment, claiming that they were not performing work at the subject intersection on the day of the accident and did not own the construction equipment that had allegedly obstructed the view. The Supreme Court denied the motions. Finally, inter alia, that there were issues of fact as to whether Brooklyn Union owned the construction equipment. We modify. Brooklyn Union sustained its burden of demonstrating its entitlement to judgment as a matter of law by submitting evidentiary proof that it was not performing work in the vicinity of the subject intersection on the date of the accident, and that it did not own the construction equipment that may have obstructed Roman's view. The evidence that the plaintiffs and the co-defendants submitted in opposition to the motion was insufficient to raise an issue of fact as to whether Brooklyn Union owned the construction equipment claimed to have obstructed plaintiff's view, or whether any other negligence of Brooklyn Union's contributed to the accident. However, the Supreme Court properly denied the motion for summary judgment, although it also sustained its initial burden of demonstrating its entitlement to judgment as a matter of law by submitting evidence indicating inter alia that it was not working at the intersection of 103rd Avenue and 127th Street on the day of the accident in opposition to the motion. The plaintiffs and the co-defendants offered evidentiary proof that he was engaged in a project to install a new water line on 103rd Avenue on the day of the accident. The plaintiffs and the co-defendants also offered proof that in connection with the water line project, they utilized some of the same items of construction equipment which allegedly obstructed the view. Under these circumstances, a triable issue of fact exists as to whether Civet owned the construction equipment that may have obstructed plaintiff's view of the intersection. In an action inter alia to recover damages for breach of contract, the plaintiffs appealed from 1. An order of the Supreme Court, Rockland County, dated February 12, 2004, which granted the defendant's motion in effect to vacate so much of a prior order of the same court, dated October 14, 2003, as, upon searching the record, awarded summary judgment in favor of the plaintiffs, and 2. A judgment of the same court dated April 28, 2004, which, upon a jury verdict, is in favor of the defendant and against them, dismissing the complaint. The appeal from the intermediate order must be dismissed because the right of direct appeal therefrom terminated with the entry of judgment in the action. It raised on the appeal from the order an issue which was brought up for review and have been considered on the appeal from the judgment. The plaintiffs brought the instant action against the defendant and electrical contractor to collect fines levied against him for operating a non-union business. The defendant contended that the plaintiffs failed to comply with the Constitution and bylaws of the Plaintiff Local 363 International Brotherhood of Electrical Workers. Thereafter, the union by failing to bring the charges within 60 days of becoming aware of the alleged violations. The Supreme Court properly vacated so much of the original order as, upon searching the record, awarded summary judgment in favor of the plaintiffs. The defendant demonstrated the existence of a triable issue of fact with respect to whether the plaintiffs failed to comply with the union's constitution and bylaws. C. Allen versus New York City Transit Authority, 109 Miscellaneous 2nd, 178. 439 New York Supplement 2nd, 811. Caliendo versus McFarland, 13 Miscellaneous Reports 2nd, 183. 175 New York Supplement 2nd, 869. $130.